In the case A11Y, the ICSID tribunal has explained that even such things as know-how and goodwill should be considered as investment. Previously, as you might know, we had so-called Salini test, we had different discussions whether investor could be considered as an investor if he hasn't brought enough money from abroad, or if he is not the final beneficiary but an intermediary one. We were discussing whether a mere ownership of a particular share could be considered as investment. Now, in this case, we go much farther. In this case, the ICSID tribunal says that even know-how and goodwill are investments. Know-how is understood as expertise of employees of the company, and goodwill is reputation and loyalty of the consumers. So in this case, we had a problem related to the expenditures of the government. So the company, the business of A11Y consisted in selling aids for blind people and those, who has different problems with sight. The government, the public institutions were compensating a part of the price to those who needed this. And then suddenly the government, the institutions, the public institutions started making different statements that the price was too high, and step by step the government started to reduce their contribution into those aids, into the help for the people to buy those aids. Finally, the business collapsed, and A11Y tried to prove that this was an indirect expropriation. Unfortunately, they have failed. The tribunal held that they didn't prove to a sufficient standard that that this public campaign by the state institutions against them was equivalent to an indirect expropriation. Nevertheless, in this case, we have a clear statement that know-how and reputation are investments. This is very interesting, and I hope this will give ground for wonderful jurisprudence in the future.